14th of March, 1950. The Israeli parliament, the Knesset, held a quiet vote. A law was passed that day that would forever change the concept of ownership. Imagine this. You wake up one morning. You fled to the next village to escape the war. When you return, the state tells you that you are absent. Your house is there. Your key is in your pocket. You are breathing. But in the eyes of the law, you are a ghost. And your deed now belongs to the state. This is not a metaphor. This is the Absentee Property Law of 1950. And by the time you finish this video, you will understand that wars are not won with guns and tanks. They are won in land registry offices and parliamentary votes. Let me take you back. 1948. The war ends. Approximately 700,000 Palestinians have left their homes. Some fled the fighting, some were expelled, some left for a few days, thinking they would return. They took their keys, they locked their doors, they believed it was temporary. But here is what most people do not know. These were not just poor villagers leaving mud huts. We are talking about entire urban centers. Jaffa, one of the most prosperous port cities in the Mediterranean. Haifa, an industrial hub, hundreds of villages with established agricultural economies. Orange groves that had been exporting to Europe for decades. This was not empty desert. This was functioning, wealth-generating property. The newly established state of Israel saw something else, not refugees, not people, assets, empty houses, abandoned olive groves, shops, factories, entire villages, bank accounts, business inventories, furniture, machinery, livestock. An estimated 93% of the land that would become Israel was now sitting there, legally ambiguous. Let me give you some perspective on the scale. Historians estimate the value of abandoned Palestinian property in 1948 to be worth billions in today's dollars. We are talking about approximately 4 million dunams of land. For reference, one dunam is about 1,000 square meters. That is 4,000 square kilometers of prime real estate. Coastal cities, agricultural heartland, commercial districts. But here is the problem. You cannot just take someone's property and call it yours. That would be theft. International law exists. The newly formed United Nations was watching. So instead, you build a legal framework. You engineer a system. You create a law that makes confiscation look legitimate. Enter the Absentee Property Law. Passed on 14th of March 1950, this law did something unprecedented in modern legal history. It created a legal category called absentee, and the definition was surgical in its precision. According to the law, you were considered an absentee if, between 29 November 1947 and 1 September 1948, you were in any Arab country or in any part of Palestine outside the area that became Israel. Let me break down how insane this definition is. The dates. 29 November 1947 was when the UN voted on the partition plan. 1 September 1948 was after the war had essentially ended. So if you were a Palestinian who, during this 9-month window, left your home for any reason, you were classified as absent. Did you go to visit family in the next village over Christmas? Absent. Did you flee to Lebanon for 2 weeks when the fighting got heavy in your neighborhood? Absent. Did you go to Jerusalem for work and could not return because of military checkpoints? Absent. Were you forced out at gunpoint by militias? Still absent. It did not matter. The law did not care about intent. It did not care about circumstance. It only cared about one thing. Were you physically present at your property during those specific dates? If the answer was no, your property could be declared absentee property. And here is the key mechanism. Your house, your land, your business, all of it would be transferred to a government office called the Custodian of Absentee Property. Not temporarily held, not frozen pending your return. Transferred. Ownership changed hands. The custodian was given total control. They could sell it, lease it, demolish it, redistribute it, do whatever they wanted. No compensation, no negotiation, no appeals process. And they did. Let me walk you through how this worked in practice. The Custodian of Absentee Property was established as a state institution. It operated like a massive real estate company, except its inventory was acquired without purchase. Within the first 2 years, the custodian had control over hundreds of thousands of dunams of agricultural land, thousands of urban properties, hundreds of businesses and industrial facilities. Entire neighborhoods in cities like Jaffa, Haifa, and West Jerusalem were now managed by this single office. Then came the redistribution. The properties were sold or leased to new Jewish immigrants arriving from Europe and Arab countries. The government needed to house approximately 700,000 immigrants who arrived between 1948 and 1951. Where do you put them? You put them in the empty houses. The Israeli Development Authority, a government agency, purchased massive amounts of land from the custodian at below market rates. This land was then used to build kibbutzim, new towns and agricultural settlements. This was not just about housing. This was about creating facts on the ground. If you fill a house with new residents, if you plow a field and plant new crops, if you establish a school and a clinic, the original owners become increasingly irrelevant. The property is now economically active under new ownership. This was the fastest privatization operation in modern history, executed with a pen, not a sword. But here is what makes it truly brilliant from a state-building perspective. It was self-funding. The sale of absentee properties generated revenue for the state. The state used this money to build infrastructure, fund immigration, and develop the economy. Palestinian property was not just confiscated, it was monetized. But here is where it gets truly bizarre. There was a subcategory within the law, a legal paradox so absurd that it defies logic. They were called present absentees. Let me explain this carefully, because it sounds like a contradiction. Imagine you are a Palestinian. You live in Haifa. The war happens in early 1948. You flee to a nearby village just 10 kilometers away to stay with relatives until the fighting stops. The war ends. Israel is established. You return to Haifa. You are now inside the borders of Israel. You apply for citizenship. You receive it. You're now an Israeli citizen. You pay taxes. You vote in elections. You hold an Israeli ID card. But your house? The state says you were absent during the critical dates specified in the law. So even though you are physically present in Israel, even though you are a citizen, even though you can literally see your house from the street, you cannot enter it. You cannot reclaim it. You are legally absent. You exist, but your property rights do not. You are a present absentee. By 1952, there were an estimated 30,000 to 50,000 present absentees, Israeli citizens, living in Israel, paying taxes to a state that confiscated their property, unable to access their own homes. Some of these people lived in refugee camps inside Israel, while their houses, visible from the camp, were occupied by new immigrants. Let that sink in. You are a citizen of a state. You vote in that state's elections. You're subject to that state's laws. But that same state has legally classified you as absent and taken your home. This was not an accident. This was not a bureaucratic error. This was the system working exactly as designed. The purpose was clear: prevent return. If Palestinians who fled could not legally reclaim their property, they had no economic incentive to come back. And if they did come back, like the present absentees, they would be economically weakened, landless, and dependent. This was social engineering through property law. Now, let us talk about the economics in more detail, because this is where it gets really interesting. The 700,000 Palestinians who fled or were expelled left behind an enormous amount of wealth. Historians have attempted to calculate the total value. Some estimates put it at over $4 billion in today's currency, but that number does not capture the full picture. Think about what was left behind. Urban properties. Entire apartment buildings, shops, warehouses, workshops, factories. Jaffa alone had thousands of properties. Haifa, Acre, Tiberias, all had significant Palestinian urban populations. Agricultural land. The coastal plain was full of orange groves. These were not subsistence farms. These were commercial agricultural operations exporting citrus to Europe. The groves were well established, mature, and profitable. Movable assets, furniture, machinery, vehicles, livestock, business inventory. Bank accounts were frozen and eventually transferred to the state. Historians estimate that absentee properties made up the vast majority of the land and housing stock available to the early Israeli state. Some estimates suggest that over 90% of the land in the new state came from absentee properties. Without these properties, the state would not have been able to absorb the massive wave of Jewish immigrants arriving from Europe and the Arab world in the late 1940s and early 1950s. Think about the logistics. You have 700,000 new immigrants arriving. You need to house them, feed them, employ them. But you are a brand new state with limited resources. You do not have time to build 700,000 new homes. You do not have the budget. But if you have 700,000 empty homes, apartments, and farms sitting there, already built, already functional, already connected to water and electricity, you just move people in. The absentee property law was not just a legal tool. It was an economic engine. It fueled the development of the state. It provided the infrastructure for mass immigration. It subsidized the economy. And it was all legal. That is the key. No international court could say it was theft because it was done through domestic law. The state passed a law. The law was applied. Property changed hands. Now pause for a second. You might be thinking, okay, but this was 1950. This is history. Surely this does not happen anymore. Wrong. This is not history. This is an active, ongoing mechanism. Let me take you to Sheikh Jarrah, East Jerusalem. 2021. Palestinian families living in homes they have occupied since 1956 are being evicted. Not by soldiers, by court orders. Why? Because Israeli courts ruled that the land originally belonged to Jewish families before 1948, and under Israeli law, Jews can reclaim property lost during the war. Now, here's the critical detail that most media coverage misses. Palestinians cannot do the same. If you are Jewish and you lost property in 1948 in an area that became Israel, you can file a legal claim to reclaim it or receive compensation. There are legal mechanisms for this. If you are Palestinian and you lost property in 1948 in an area that became Israel, you're classified as an absentee under the 1950 law. Your claim is void. The property belongs to the state. You have no legal recourse. The law only works in one direction. This is not a bug in the system. This is the system. Sheikh Jarrah is not an isolated case. This mechanism is being used across East Jerusalem. Families who have lived in homes for 60, 70 years are being told they are tenants on land that belongs to Jewish organizations. Eviction orders are issued. Families resist. The images go viral. But the underlying mechanism is legal. Let me give you the current numbers, because this is not just about East Jerusalem. According to recent reports, in 2024 alone, Israel declared 12.7 square kilometers in the West Bank as state land. This is land that Palestinians were farming, living on, or using for decades. But the state declares it unclaimed, or absentee, or not properly registered, and takes control. Once it is state land, it can be allocated. And who does it get allocated to? Israeli settlements. As of 2024, there are over 700,000 Israeli settlers living in the West Bank and East Jerusalem. These settlements are considered illegal under international law, but under Israeli domestic law, they are legal because the land has been reclassified as state land. The Israeli Civil Administration, the governing body in the West Bank, has a department that examines land records. If Palestinian land ownership cannot be proven with Ottoman-era or British Mandate-era documentation, which most Palestinians do not have, the land can be declared state land. Sound familiar? In 1950, it was the Custodian of Absentee Property. In 2024, it is the Civil Administration and the Declaration of State Land. Different names, same mechanism. The method has not changed. It has just been updated for modern bureaucracy. And here's the scale. Since 1967, Israel has declared approximately 30% of the West Bank as state land. Settlements have been built on this land. Roads have been paved. Entire cities have been constructed. This is not random. This is systematic. So let me connect the dots for you, because this pattern is not unique to Israel and Palestine. This is a method that repeats throughout history. In the United States, the Indian Removal Act of 1830 forcibly relocated Native American tribes from their ancestral lands in the southeastern United States to territories west of the Mississippi River. The legal justification? The land was deemed unoccupied or underutilized. Native Americans did not have European-style property deeds. They did not farm in the way Europeans farmed. Therefore, in the eyes of American law, they were not legitimate owners. The land was then sold or given to white settlers. Entire tribes were marched thousands of miles. Thousands died. But it was legal. Congress passed a law. The president signed it. The courts upheld it. In England, the Enclosure Acts of the 18th and 19th centuries privatized common lands that had been used by rural communities for generations. For centuries, peasants had the right to graze animals, gather wood, and farm on communal lands. The legal justification? Efficiency, productivity, modernization. The land would be more productive if it were privately owned and managed. So Parliament passed laws allowing landowners to fence off the commons. Peasants who had relied on these lands for survival were displaced. Many ended up in urban slums or emigrated. But it was legal. In South Africa, the Natives Land Act of 1913 prohibited black South Africans from purchasing or renting land outside designated reserves. These reserves made up less than 10% of the country's land, despite black South Africans being the majority. The legal justification? Racial separation, development, order. Millions of black South Africans were confined to these reserves. Their ability to own property, build wealth, and pass assets to future generations was destroyed. But it was legal. Parliament passed it. Do you see the pattern? In each case, the method is the same. First, you legally define the current owner as absent, invalid, uncivilized, or racially inferior. Then, you transfer ownership through law, not through force, through law. Force is messy. Force creates martyrs. Force invites international condemnation. But law is clean. Law is legitimate. Law can be defended in court. Law creates a paper trail that historians will argue about for centuries. Empires change, borders change, governments change, but methods do not. Now, here's the uncomfortable truth that no one wants to say out loud, because it challenges something fundamental. You think your property deed means something? You think ownership is permanent? You believe that if you have a title, if you pay your taxes, if you follow the rules, your property is yours. But history shows us that ownership is only as strong as the legal system that protects it. And legal systems can be rewritten. The Palestinians who fled in 1948 had deeds. They had keys, they had tax records, they had family histories going back centuries. None of that mattered. Because the state had the legal authority to redefine reality. And once the law says you do not exist, you become a ghost. Your property is still there. You can see it, you can touch it, but legally, it is not yours anymore. This is the power of law. It can create ownership out of nothing, and it can erase ownership that existed for generations. So what is the lesson here? This is not a story about one specific conflict. This is a story about how power consolidates itself, not through violence, not through propaganda, but through the quiet, bureaucratic machinery of law. The absentee property law was not a weapon of war. It was a weapon of construction. It built a state. It funded an economy. It erased a population from the legal record while leaving them physically present. And the mechanism is still running in the West Bank, in East Jerusalem, and legal frameworks around the world. If you want to understand what is happening today, you do not need to read political speeches. You do not need to watch the news. You need to read land registry records. You need to follow property transfers. You need to see who signs the deeds. You need to understand who writes the laws. Because wars are not won on battlefields anymore. They are won in courtrooms, in parliamentary votes, in the fine print of legislation that no one reads until it is too late. This was not a story about good guys and bad guys. This was a story about a system, a legal mechanism, a framework designed to transfer wealth and property on a massive scale. The absentee property law is one of the most efficient tools of displacement ever created, and it was entirely legal. History does not repeat itself, but mechanisms do. So the next time you hear about a conflict, do not just ask who is fighting. Ask who is signing the deeds. Ask who controls the land registry. Ask who writes the laws, because that is where the real war is being fought, and that is where it is being won. If you want to see the truth, do not look at the maps. Look at the property records. History hides the answers. I'm just showing you where to look. If this video opened your eyes to how power really operates, hit the subscribe button and turn on notifications. This is the kind of research that does not show up in mainstream narratives. Leave a like if you want more deep dives like this, and share this with someone who still thinks wars are won with weapons. Because they are not. They are won with paperwork. See you in the next one.